My Lords, the exception to the rule on double actionability, I'm going to take this, I think this is the most efficient way to do it, primarily from the judgment and make my submissions as I go along. So could we go back to the judgment, Core Bundle, tab 6, page 167. And you've seen the rule in Dicey and Morris and the exception. And if we go to page 170, the Tribunal's treatment of the exception starts at paragraph 98. And there are citations from Dicey and Morris in 98 and 99, and we see at the bottom of the citation in 98 that the exception exists and it's only designed to take account of unusual cases. It will, in those cases, produce more appropriate results than will the reasoning. So it's an exception. It exists, and it's designed to take account of unusual cases. And then we see at 99 the citation from Dicey and Morris that discusses the various circumstances in which the exception might apply. And you see this. So the strength of the case for displacement may also depend on the type of issue before the court and perhaps the kind of tort complained of. Lord Hodson, in particular Lord Wilberforce, that's in Boys and Chaplin, recognised that it was necessary to isolate the issue in the case in the process of answering the question whether the general rule of double actionability should by way of exception be departed from. For the law which has the most significant relationship with the occurrence and the parties is to be identified in the light of the issue in the case. So its most significant relationship with the occurrence and the parties. In Boys and Chaplin, the issue was heads of recoverable damages. In light of the English residence of the parties and their temporary presence in Malta, that issue was most significantly related to English law. The position might have been different if, for example, the issue had been that of the quality of the act or of standards of conduct, e.g. whether the defendant was strictly liable or liable only for negligence or gross negligence. In respect of such an issue, the case for displacement of the general rule may be weaker, since it may be persuasively argued that standard of conduct is intimately connected with the place where the conduct occurs. Might thus be, though, that this issue should be considered by reference to the general rule, and there's normally no room for the displacement of the general rule when the issue is peripheral to the law of torts or belongs to another branch of the law. The case for displacement, I'm going to the bottom of the page now, may also depend on the particular kind of torts before the court. So it's a general, you have to look at not only the torts, but the issues arising in the case. And the Tribunal found, of course, that the exception applied, and we see its reasoning at paragraphs 100 and 101. And you see at 101 that at 100 that it had regard to the following factors, which are there listed. There are 5. And then at 101, although these factors are not all of equal weight, taking them together, we consider that this is an unusual case where there are clear and strong grounds for the exception to apply as regards the issue of limitation and prescription, and that the governing law for that issue should be the law of the place where the loss was suffered. Now, focusing on the 5 factors, so factor 1, application of the general rule by reference to the substance of the tort is problematic and unsatisfactory for the reasons set out above. And that's going back to the point that if the general rule points to, so part of the tort, the court accepted, the tribunal accepted, took place in the place where competition was restricted, and so double actionability applies. But then that's unsatisfactory for the reasons that we've already canvassed, which is that it gives rise to a number of different applicable laws. And that's obviously a relevant point to take into account. And then 2, the primary basis of liability of MasterCard is breach of EU competition law, which applies throughout all EU member states. MasterCard's not being held liable for acts which were lawful under the law of any of the other countries, which it contends should be the governing law. And that is also a relevant point, and it's an important point because the rationale for the rule, the double actionability rule, and we see this in Boys and Chaplin, I'm sure that your lordships are aware of this, is to avoid the situation where an act takes place in a foreign country where it's not tortious and the defendant sued in England where there is a tort, in circumstances where there's little connection with England, because in such cases the unfairness is obvious. But that just doesn't arise here, because the breach is breach of Article 101 that applies throughout the EU, so it's just a very different type of case. Then third, the issue for which the exception is being applied is limitation, and that's not part of the substantive tort here being applied. And again, that's a relevant point. You see that from the citation in Dicey and Morris, that you've got to isolate the issue for which foreign law is being put forward, and here it is limitation. That's the reason why foreign law is being pleaded. And it doesn't have any connection with the substantive tort. And so we're not in the kind of case where the defendant is saying, well, hang on, the tort was committed in France and you're seeking to apply the substantive law of England in circumstances where the law of France is very different. It's not that situation at all. Then we see factor 4, the acts which MasterCard itself carried out that give rise to the tort, as opposed to the consequences of those acts, were its rules and determination of the MIFs, which were to apply throughout the EEA, including in the UK. So again, there is no specific connection between the breach and any other particular state. And then 5, neither the class members having the claims nor MasterCard as defendants have any connection with the various foreign countries from which remote sales were made. Now, MasterCard makes the point, reading this rather literally, well, of course there is a connection because purchases were made remotely from those countries, but of course that isn't the point the tribunal's making. No. The tribunal's saying that there's no particular connection with any other particular country. And so we say that all of these reasons are relevant reasons. They're all reasons which the tribunal was entitled to take into account. We say that they're correct. That there's no error of principle in the tribunal's approach. On the contrary, the tribunal reached the right conclusion. I'm not going to repeat all of the submissions I made earlier under the head of Section 12, but they are also relevant to the assessment under the common law. So those are my submissions on the common law, unless the court has any questions for me.
Thank you.
Thank you. Can I just remind the tribunal what the test was, sorry, the Court of Appeal, what the test was the tribunal applied at paragraph 88 of the judgment. The test, if you have it in front of you, is its significance in terms of the tort seen in the abstract was one question, or... I'm sorry, I moved that, didn't I? Better, great. Or the test they applied, which is significance in terms of the part those events will play in the proceedings. So the test the tribunal applied to Section 11, and we see also to Section 12, starting with Section 11, was that the relevant test under Section 11.2c was significance in terms of the part those events will play in the proceedings. There is absolutely no justification on the statutory language for that test. And my learned friend today developed a new case, but her skeleton seeks only to defend that test, and that was the basis on which my learned friend defended finding on Section 11.2c. And if I can remind you of my learned friend's skeleton, it's at tab 20, please, of the core bundle. And if you can look, please, at paragraph 11. That's 11, it's tab 20. Beg your pardon, that's mine. Let me find the right reference. It's tab 24, please, paragraph 11. And what the way in which my learned friend sought to argue this appeal on both on the application, resisting the application for permission and in her appeal skeleton, it is on the basis that the tribunal was right to apply the test that they did, and she also prayed in aid what she said Mr. Justice Barling had found in paragraphs 16 and 17 of her skeleton. So That is the basis on which this appeal is defended. No respondent's notice has been put in, and I do take a point on that if a new argument is going to be advanced orally for the first time, because it's not in the skeleton, not in a respondent's notice. And the new case, which was argued, which was not, even though I asked, tied into any paragraph of the skeleton, was that there must only be one single country, i.e. significance must be tied to which country. That is no part of her case, but in any case, it's completely wrong. And the reason it's completely wrong is for several reasons. First of all, it is inconsistent with Mr. Merrick's own pleading in paragraph 2 of the claim form, where the pleading is set out, paragraphs 2 and 5, where it's very clear that it's said that the claims are combined, they're not just one claim. Secondly,
Sorry, that is a different point. That's combining claims of each individual class
that's
member.
right, but it said it's got to be tied to one country, so you've got to look at the claims together. Was my
If there is a
point.
shocking lacuna in the pleading, isn't this something which, if the law is clarified or confirmed or amended by us, can be remedied after the event?
Well, not really, because it's a respondent's notice and and it's not been put in the skeleton, so it would be grossly unfair for it to
by
be
the
argued
cat.
now.
If there's a deficiency in the pleading, can't it be remedied by the cat at a later date?
I think the point is, my lord, that her skeleton, her pleading is in accordance with the collective proceedings regime, section 47 and B, that individual claims, there are individual claims, that is the collective proceedings regime, are combined in order for common issues to be litigated together and to take advantage of 2 points, and you see this from the Merricks Supreme Court judgment you were shown. The first is the concept of opt-in, opt-out, and the second is aggregate damages. But what is very clear from the competition rules, as I'm sure my lord knows, is that these are individual claims combined for those procedural reasons and the damages regime. They are not one action, and my learned friend's pleading therefore can't be amended because what she is pleading is in accordance with the regime that she is relying on. The second point as to why this argument is wrong is it's completely contrary to the approach taken in relation to the Scottish class members below, where it was agreed that their claims were governed by Scottish law, even though they were just part of the overall class and limitation was determined for that group accordingly. So there was not just approached on that basis. The second point is that my learned friend mischaracterised my case as that the tort elements had to be looked at in the abstract, taking that from what the tribunal said in their judgment. That was no part of my submission. On the contrary, I said yesterday, day 1, pages 20 to 21, 31 to 32, and 41 to 44, that the exercise has to be done on the facts. What that means, though, is not, as I said at length, an exercise where you look at the stage that you've reached in the proceedings, but the actual facts of the case of the tort. And that is what Mr. Justice Barling did. It's what we see in the cases I showed you, where the exercise under 11.2c was done, Mr. Justice Aiken's judgments. And that is the exercise that is done. I'm not saying in answer to the Chancellor's point that it would be the same for every breach of statutory duty or every breach of Article 101. But what I would say to you is, for example, you did see in the judgment in Sebastian Holdings, Mr. Justice Cook saying, in deceit and misrepresentation cases, it's well established that the continuum of reliance and location of damages are the most significant elements. So it's not a surprise for it to be suggested that where the restriction of competition will be the most significant element in many Article 101 cases. But I don't need to show you that that's always going to be the case. I need to show you that here. And I also need to show you that the tribunal accepted, and again, this is not subject to a respondent's notice or a challenge, the tribunal accepted that but for the application of the test that they applied, which was to look at the issues in these proceedings where we are now. Had they not applied that particular test, they would have followed the decision of Mr. Justice Barling, and that hasn't been challenged. So what I would say is that my learned friend can't now advance effectively either a challenge to the tribunal's judgment, to Mr. Justice Barling's approach, or to introduce a new argument that there's a single country and that's the test, not least because it would be not just unfair but inconsistent and wrong with what happened below. My learned friend also did not address my point that the reference in the authorities we've looked at about the facts arising in the case, which were principally Deutsche Bahn at paragraph 124 and Protea at paragraph 78, are to the facts at the time of the infliction of the tort. And I showed you the Law Commission reports, and we had a long debate about this yesterday. Section 11 has got to be at the time of the infliction of the tort. So that is why, in a nutshell, there are lots of reasons, but that is why, in a nutshell, the test applied by the tribunal cannot be right. And that is absolutely plain from everything we have looked at. And just to clarify one final point on section 11, in paragraph 17 of my learned friend's skeleton, and paragraph 16 in particular, my learned friend purports to quote from Mr. Justice Barling's decision in Deutsche Bahn, but we can't find, and will be corrected, the quote in the light of the facts of the case before it, as meaning what she is attributing it to mean, i.e. the issues that have arisen. So, although the reality is that my learned friend presented her submissions as tied into the statutory wording of section 11 and had a debate with my Lord Justice Snowden about that, they're not tied in at all for the reasons my Lord Justice Snowden identified. It's not an exercise about tying significance to one country, and nothing on the wording would in fact fit with that construction. But more than that, her wording and the attempt to move to that single country analysis makes no difference, in fact, to my fundamental objection, which is where my learned friend gets to, is that she has to ask you to look at proceedings as they currently stand, rather than when the tort was inflicted. And that's why section 11 is not open to her. Can I then move to section 12, because I understand that that's, in a sense, has become the real battleground as to whether section 12 allows that sort of inquiry. And just to clear away, I accept, first of all, it's a wider inquiry, it clearly is, and I accept that it allows, on the face of it, to the extent of the factors that are relevant, some inquiry post the infliction of the tort, because it refers to the events after that. But the starting point is, and this was not grappled with, it is going to be an exceptional case where, having gone through the exercise of section 11(2)(c), identified the most substantial element of the case, and then said that should then have the relevant governing law applied, to then displace it, and for all the reasons we have seen in the case law. And the reality here is that my learned friend has not produced a single authority that would support her approach.
Well, that's because this point hasn't arisen in the context of follow-on claims before. I mean, in the case of a standalone claim, such as Deutsche Bahn, perfectly obvious why it is you get to the answer that it's the restriction on competition. Well, in a follow-on claim where the Commission has decided that there is a restriction on competition, it's illegal, then the position may very well be different.
But that's not right. If that's, then I'll have to be, if that's going to now become the main factor. The first point is that there obviously are not going to be very many cases on follow-on claims in the collective proceedings regime. Just put that to one side. There are cases, the Rohig case, where there was an admission of liability, but nevertheless, the relevant law analysis of the law still took into account that issue of liability. It didn't just, the court didn't just say, right, because it's been admitted, we're now going to move to Dutch law, which was what happened, which was the debate in that case. So that is, it's the ROHIG, R-O-E-H-I-G, that case. And the reason, and my learned friend hasn't gone through those authorities, the court asked me to produce, which we did, the 4 authorities, there are only 4, showing when displacement has been found to be appropriate in the context of multiple Court of Appeal judges saying that it would be it's an odd exercise, it's a rare case. And the point of it is that the 4 cases, as I said to you, have one consistent theme, which is tied into the law. It's tied into the proper law of the tort and the nexus between the governing law agreed by the parties in respect of a contract with a tort that forms part of the connection to it. So that is the scenario, and I've shown you the Law Commission report that demonstrates that that's what they had in mind when extending past the date of infliction. There is no suggestion that policy factors or factors about the litigation events should suddenly now define the applicable law to a cause of action. That is a remarkable interpretation of Article 12.
It may well be that the draftsman or draftsperson of the 1995 Act, Section 12, might agree with you in the sense that collective proceedings were not even a glimmer on in the draftsman's vision at that stage. And indeed, I suspect in all of the case law where we've seen courts saying it should be an exceptional case or otherwise, there was no concept that they would be thinking about collective proceedings. But nonetheless,
but can I come on to collective
this section
proceedings?
does have to be applied in collective proceedings, and as you said, collective proceedings are still exceptional cases. They are unusual cases in our. You may be doing a lot of them, but they're in the general run of them. In the general run of litigation, they are unusual and exceptional, and we have to look at Section 12 and then interpret it in the current legal environment, which now includes collective proceedings.
Added to which, outside the context of the myths, most of the collective proceedings cases that are before the CAT and that come before this court, so there have been cases where issues as to applicable law haven't arisen because they're effectively intra-UK disputes. Things like Gutman with the boundary fares is all to do with fares on the London South Western and London North Western Railway, etc., etc.
So can I take it that one of the things that I would ask the court to have in mind is that, I don't really need to ask this court to have this in mind, but there has to be, with my respectful submission, intellectual rigour about the analysis of Section 12. And the reality is that if we're going to look at the impact of collective proceedings, I'm going to come on to that. But at the moment, there's a real risk in my learned friend's submission, certainly, of the tail wagging the dog. Because the starting point is we have to look at the language of the statute and what it's trying to do. And then I can come on to my Lord Justice Snowden's point, which is a fair point of the collective proceedings regime. But the language of Section 12 is about the governing law of the tort. And in answer, first of all, did the draftsman have it in mind about collective proceedings? Well, yes, in a way, the draftsman did. And I'll come on to the particular aggregate damages point. But I showed you in the consultation paper the paragraphs, I think it was 6.58 of the 84 consultation paper, where it was multi-party actions were discussed.
There's a difference between you and Mr. Mutiu on the wrapper point, if I can
Well, I'll
put
come
it
on
that
to
way.
that.
Because I don't think she doesn't accept your characterisation that this is just a whole load of individual claims. She says, well, look, there is a very substantially different legal animal in that wrapper.
So, the first point is that the law consultation paper talks about the fact that you have multi-party litigation, and it shouldn't change the analysis over the applicable law. You have to analyse the individual claims. And I've shown you the two cases
So
that
if you
support
had
that.
half a dozen claimants, each pursuing their own claim that were for convenience listed to be heard together, each would have to show duty, breach
Yes.
and loss.
Well, not just if they're listed together, that was about multi-party actions as well.
Suppose they're for convenience that 5 of them had clubbed together and instructed the famous science solicitors and were claimants 1 to 5 and
Yeah.
pleaded their cases separately. The point that's made, as I understand it, is that collective proceedings they're not simply a procedural device like that. They would allow for the possibility that a member of the class will receive compensation even though they may have suffered no loss, for example.
Well, can I take each of those points in turn? First of all, I say it's a wrapper because the language of 47B is that it is individual claims combined together. And the combination is for the procedure. And I think the statute makes it plain, as indeed my learned friend's pleading is on the basis of, that everybody has to have a cause of action. So it's not a different legal animal than any other multi-party case to that extent.
Well,
you each have a cause of action.
Say for this, where ordinarily loss is an essential
coming on to
requirement
loss.
for a
Can I
cause of
develop
action, stated as baldly as you just stated it, I'm not sure that's consistent with a couple of paragraphs that we saw in Merricks, where the point is made that even where loss is an essential element of the cause of action, you can have people in your class who haven't suffered loss.
Can I come on to this? The starting point is the cause of action. So the loss doesn't define the cause of action, it's one element of it, that you've got to have a cause of action. And the analysis in the Law Commission reports and the cases is that if you've got multiplicity of parties, you have to analyse each of their causes of action, and the Competition Act makes it plain that each person should have a claim, a cause of action. Now, the question has come up about loss, and in Mr. Merrick's class, as you remember, the CAT refused to certify because of concerns about the class, and indeed the minority would have done the same about the class definition. And there is a debate about whether or not it's appropriate to have people within the class, and it's not just the Merricks case, there are other cases who have suffered no loss. And the answer, I think, as a matter of principle is, people may get caught within the class who either have no loss or who are proven to have no loss when it comes to distribution. That's the Gutman, I think it's the train tickets case, the rail tickets case. But that's a part of the class definition, and it ought to get sorted out at the stage of distribution. It's not the case necessarily that anybody in the class will get paid, even though, and the Merricks case may be different in this regard, but I don't think there's any other case in this way, that just simply because of the collective proceedings approach. But more significantly than that, I have 2 further points on loss. The first is, if it's right that loss is so straightforward, as my learned friend presented it, and it's all in the aggregate and so on, then it can't possibly be the most significant element of the claim, if she's right, because that's a given according to her, everybody's going to get paid. So it can't possibly be the most significant element of the claim on her analysis. The second point is that if you break down what the position is on loss, all you're really saying is that the wrapper has provided a mechanism where loss is not proven individually. It's an aggregate. But within that, you still don't allow people to have revived statute-barred claims. That is common ground. Limitation still works. So the danger of the tribunal's approach, and if the Court of Appeal takes the same approach, the danger is...
Does the limitation come in at the start or the end?
Well, on this analysis, possibly at the end, if it's also clear that loss is all wrapped up in one and everybody who has a claim.
Well, I'm just taking your, as I recall it, your answer about somebody who actually had suffered no loss being found to be in the class, is that...
That's a distribution.
You deal with them distribution.
That's right.
why wouldn't you adopt the same approach as somebody with a limitation, where there's a
Because
limitation defence?
We don't, because when you're talking about distribution, you're talking about getting the money. With limitation, you're talking about whether you've got the claim, have a claim that you're entitled to bring. And what I'm concerned about, and I am going to put it very starkly, if the court wants to take a policy decision that all collective proceedings should have one law and one law of limitation, so that's what this case is about. The Chancellor put to me very pithily yesterday, why are we here? Why am I making these submissions? Well, it's on both sides. I'm trying to preserve the possibility of limitation defences, and my learned friend is trying to ensure that MasterCard won't have the benefit of accrued limitation defences under foreign law. That's what the fight's about. So if you go down the route of saying, well, let's look at where we're on the proceedings, it's all about loss, therefore, to make it all easier, we're going to apply English law, which is what the tribunal did, because then you've got a single law. What you're actually saying is that the issue of what law is applicable is actually irrelevant. It's not a conflicts question at all. It's saying we think it's better to have collective proceedings managed in a particularly easy way for consumers. And actually, we're going to, by the back door, abrogate all the approach that's been taken, even in the collective proceedings context, to preserving limitation. This has always been accepted in the Competition Act, subject to my learned friend's arguments on the next point, that limitation defences were preserved. Even she accepts that they were certainly preserved till 2015, and then we're going to hear a debate. But this is a way of the law basically determining that there is no limitation defence, the applicable law, and that can't possibly be what Section 12 was geared towards. And it can be put terribly attractively that this is consumers' collective proceedings, it's different from the Section 11 analysis, we're looking realistically, pragmatically at where we are. But you can see that that's no part of the inquiry under Section 12. If the courts want to say collective proceedings should be managed differently when it comes to limitation and
that's
law,
a sort of plea in terrorem with respect, Mr. Lake.
Well, but
because if the arguments about Section 12, I mean, there are a series of arguments about Section 12. If they're right, then the applicable law is English law, and there is no foreign limitation defence available at all.
but that's not right.
I mean, that doesn't necessarily, that's not necessarily dependent upon this being collective proceedings as such.
But that's
because
why,
there are a number of factors that
but
are
that's
relied upon.
why,
Mr. Mitru's main point, as I understood it, was the point about the restriction of competition not being an issue. Well, she's right about that. Then it's a bit difficult to see why she's not right across the board on Section 12.
well, Mr. Mitru didn't address, though, on that point, taking that point, if she's right about that, that means in 2017 the proper law changed due to the Commission decision. On her case, an issue doesn't arise in a case because if it's admitted, that's not correct. And secondly, the proper law changes however long after the commission of the tort because, and that's what happened here.
Isn't that just the effect of Section 58? Parliament has intervened to make the decision binding as the fact and to law, and that then has consequences in the way it enmeshes with Section 12.
So that means if a party decides that a particular law is more beneficial, they can admit an issue of liability to get a better law.
Well, I'm not sure that that's right. I mean, it's one thing for Parliament to say, in cases of this type, this point will never be an issue, we Parliament say so. And in a sense, we must then read Section 12 consistently with that parliamentary diktat in Section 58. I understand your point, which is that it shouldn't be for the parties to engineer a floating applicable law. Can I just go back to one point? Is your point really on the abrogation of limitation defences? Are you saying this? You're saying if you go through 11.2c and you get to an applicable law under the general rule where there would be a limitation defence, it can't be, quote, substantially more appropriate as you would say, would actually be inappropriate to change that applicable law for something else. And so your argument, I think, focuses on the appropriateness of depriving somebody of an accrued limitation defence, which they would have under the general law identified in 12(1)(a).
It would. And that's why I was saying that interpreting it in a way that does so not only would be inappropriate under the statute, section 12, it would also be inappropriate under the very regime that, in a sense, the court's trying to enforce, the collective proceedings regime, because it's inconsistent with the approach taken under that very regime.
This goes to the heart of the question as to whether you say the collective proceedings are not intended to do away with any limitation defence which might be available in an individual case, and the assertion that collective proceedings are intended to be a sort of composite proceeding, which will permit there to be some rough edges in the constitution of the class and the distribution of the results at the end of the day. Because that's where I see the difference between you. I think you're saying, no, you must just treat this as a sort of a bundle of individual claims. And by putting it into a wrapper, you don't do away with...
I am for the purposes of applicable law,
Yeah, well,
and
that's what we're
had the
talking about.
regime wanted to do something different, there was every opportunity to say so. And claims are treated individually in two respects. One is you've got to have a cause of action to combine, and two, if you have a limitation defence to the claim, it's and a limitation argument, that's permissible within the regime. That was what the Chancellor said to me, that you don't...
What's the authority for the latter proposition?
I will find that. We know that that's, if we can pass that to you, we know that is the case, and the Chancellor was referring yesterday to the fact that you wouldn't sweep away all the cases or sweep away all the defences just because you're in collective proceedings regime. So to some extent, there has to be an individual analysis, and it's not right to say if it is just one claim, then an awful lot of the rules would have no content at all.
The second half of paragraph 95 of Merricks in the Supreme Court sort of addresses this point. It says you don't, the tort no longer requires you in effect to establish liability towards a claimant, provided you establish it to the class. So in other words, you might have a liability, a limitation defence, and for that reason there would be no liability towards that particular claimant. But it then says it doesn't matter. This is the sort of second half of the Sales and Leggett, which I think is consistent on this. I don't think they disagree with the majority. But then you've got paragraph 58, which Lord Briggs says that the principle is, quotes, radically modified.
But the individual's claims would determine the value. So it's not irrelevant.
In one sense, wrapper is a bit of a misnomer. Yes, you've got a wrapper, and that's your 47B.
Exactly.
Then you've got 47C aggregate damages. Then you've got section 58. So section 58 takes out the breach. Section 47B and C create a wrapper which takes out the requirement to establish individualised liability. Once you combine all those statutory provisions together, this is a very ameliorated tort compared to what you get in Winfield and Jolowitz. And don't we have to then look at that new statutory structure in the light of section 11 as well? And I can see if Mr. Mitri is right on section 11, then actually your case may have some force because there's not much difference. She's wrong on section 11. You can see that section 12 has a different purpose. It's not looking at the abstract. It's looking much more granular way at how this operates in the case.
Well, I think section 11, with respect, I don't think Mr. Mitri's case can be right because it is tied to the time infliction of the tort. There are lots of other reasons, but that in itself, I think, is a problem. The section 12 is a wider inquiry, but it's in relation to the elements of the tort. It's not bringing into
the context of the case and the
in
parties.
the context of the case, but
But
with respect to Mr. Mitri, a lot of the phraseology for in respect to the case is her phraseology. If we go back to, and I don't want to take too long, but Mr. Justice Barling's decision, he's talking, when he says the actual facts, what he's talking about, and as the case demonstrates, and I gave you the references yesterday, he is talking about the facts of the tort. He is not talking about the facts of the litigation. There is not a single authority talking about looking at the stage of the litigation and case management. And that is the test the tribunal applied, and the test being defended by Mr. Merricks. And it's very easy to say we're looking at the facts, but it's the facts of the tort. We're looking at the law of the tort. And it goes beyond it to look at the parties where there's a pre-existing relationship which might dictate that they have got a governing law that captures the tort. That's a very far cry from saying, as a matter of case management, because we want consumers to recover more easily, we're going to say that the loss is in one place and a single country. And if I could just show you as well, just in response on this anyway, I mean, it's not quite on this point, but in the Merricks Supreme Court decision, I note that it was said at paragraph 132 that the extent to which merchants might have passed on the overcharge to their customers rather than absorbing it themselves will depend on the markets in which they operated and on their own business strategies. So in any way, the classification of loss being all about where the consumers are isn't actually consistent with this judgment or the reality of the analysis anyway. And so that's why I'm saying to you, what this actually comes down to is not an analysis of what's the most significant element, whether under 11 or 12. This would be more convenient in a collective action with 98% of consumers based here is what's being said, or transactions, to have one single law so we don't have lots of issues about limitation. That is the submission in reality. And that's what I'm saying to you is no part of the analysis under 11 and 12.
Well, which is why I asked you what's the authority for the proposition. I mean, given paragraph 95 of Merricks in the Supreme Court, which it's quite interesting to look at it. It says you can establish liability on a class-wide basis without any individual people establishing essential elements of their claim. So in other words, you can have liability established on a class-wide basis even though there may be nobody within the class who could establish liability on an individual basis, taken to its extreme. And yet, apparently, you're saying, but.
Well,
with
I think we're going to come on to limitation, but the authorities you will see are 16.1 of the Interpretation Act, the U-Bond Tree case, and DSG in the Court of Appeal. And the three of the authorities do appear to be very clear that you can't deprive an individual of limitation, accrued limitation defences without very clear wording. And my learned friend's case is obviously going to be about whether 31.4, the omission of that is sufficiently clear on the facts of that particular argument.
Right, but so you say, well, just so I've got it, I mean, you say, well, if that's right, that you can't, without clear wording, deprive a defendant of an accrued limitation defence, then when you look at section 12, the one thing can't be substantially more appropriate is to choose a governing law other than the one that you've identified in 11.2c,
yes,
which has precisely that result.
Correct. And I also say that I think it's inherent in the collective proceedings regime that limitation defences are preserved, right? That is certainly the discussion we had yesterday, and so it wouldn't be appropriate to do it anyway.
You don't know whether or not the foreign limitations are more favourable.
Yeah.
No, I don't, and that's the truth.
But I mean, as my lord says, you've got a limitation defence. It's just under the applicable law. No one's denying you a limitation.
Well,
it may or may not be better. Maybe worse. You may get 12-year limitation, 15 year.
Indeed, but you would.
But section 12 is looking at, and when it talks about substantially more appropriate, what it's focusing on is whether the applicable law is substantially.
Indeed, but
whether the law of the other country is substantially more appropriate.
Yes.
And if it is, well, then there may be foreign limitation defences available. What you can't do is bootstrap it by starting off by saying, well, I've got foreign limitation defences under the law of France, Germany, Bulgaria, etc. Therefore, Section 12 can't make English law the more appropriate applicable law because it's depriving me of an accrued limitation defence because you haven't got a accrued limitation
But I'm not the one
defence.
bootstrapping with respect, my lord, because I'm saying.
Sorry, that was probably sounded a bit offensive,
No,
but the point I'm trying to make is it seems to me
I understand
the
that,
argument's
but
back to front.
my point is that is actually my learned friend's position.
No, I don't think
Because,
it is.
and if I can develop that, because my point is that if you apply Section 12 as I suggest it should be applied, and all the authorities are in support of that it doesn't go to case management points, then the fact that this is a follow-on action, collective proceedings and consumers, and the tribunal, I do not think it's plausible to read the last sentence of 89 as my learned friend suggested. The tribunal did not put it as part of its reasoning that these were consumer claims or follow-on collective proceedings. Sorry, not the follow-on collective proceedings. It's my learned friend who's pressing those points on you to say that they form part of the Section 12 inquiry. And the reason it's being pressed on you, it's relevant, is because she says under my case, there are multiple different laws and that takes you into the limitation territory. So the target of my learned friend's submissions is the end result that she perceives. And the court can't go down a route of ignoring that and yet simultaneously have regard to case management concerns.
I thought the answer you were going to give to the Chancellor's point.
I'm sure there's a better one.
Well, no, it's just I thought what you were going to say was that the whole premise of Section 12 is that you conducted the inquiry under Section 11(2)(c).
Exactly.
And found, as it says in 12(1)(a), that under the general rule there is an applicable law which
That's right.
is let's say on this hypothesis, let's just pick Belgium for example, I know that's featured. And the question under Section 12 is, notwithstanding that is where you would be under the general rule, whether it is substantially more appropriate to apply...
To displace.
To apply another...
To apply, and there's got to be a real reason.
And you say, well, if under Belgian law, that being the law that I arrive at as part under the general rule, 11(2)(c), there is a particular limitation period which gives, in fact, you say, may give you a defence. What you can't do under 12 is to say, well, it's substantially more appropriate to determine the issues in the case to adopt an applicable law which deprives you of that.
That's right.
Defence. So you say that's the, whether you're right or wrong, I'm not saying, but you're saying that's how you get into it.
Well, I do, and I do it in two routes. One is that if that is the consequence, so in answer to my Lord the Chancellor's point, I'm not bootstrapping, because what I'm saying is if that were to be the consequence, it could not be more appropriate.
Well, so in other words,
12.
let's go let's just move away from the facts of this case and just go to those cases in which, as you accept, Section 12 is found to apply, which is misrepresentation cases. So if the point that my lords just put to you were right, even if on the basis that the contract's governed by English law and it's a misrepresentation inducing the breach of contract, therefore applying those authorities, including Deutsche Bank, you would conclude that the tort was also governed by English law rather than French law.
Because the parties have actually agreed it.
You would say, because under the general rule law, I would have had a limitation defence. Therefore, Section 12 can't operate in the way in which it would otherwise operate because I'm being deprived of the limitation defence.
No, I'm not saying that. The Section 12 cases are in a situation where the parties have an agreement. So they have agreed that their dealings would be governed by a particular law, and therefore that's a highly material factor in why it's so rare. The second point is that I'm saying that not that you would reach a different conclusion, but you're stopped effectively under Section 12. It's part of the mix as to why it's not appropriate. And so you never get to the conclusion. So I don't put it in the negative way you've put it, which is to say, I've reached a conclusion that another law would be appropriate, but I won't apply it.
I think we probably ought to move on, really.
Yeah.
I simply don't accept that, because it seems to me that Section 12 is focusing on the applicable law, the appropriateness of a different system of law, and isn't looking at what defences or claims might be made under that applicable law. It's just...
Well, I agree with that, but that's why
There's no defence of limitation exception.
That's why, my lord, I say that the mischief arises if you treat Section 12 as looking at the litigation at all. You're looking at the law of the tort. That is not affected. Like here, this is due to the procedural form of the action that you may be concluding, because that's what we've ended up saying. If it's because of the collective proceedings, the procedural form of the action and the nature of it is what would drive a different conclusion under Section 12. And that is why I'm saying it should be no part of the inquiry. I don't think you ever get here. It should be to events connected to the tort, not to the proceedings.
Well, but hang on, the limitation is a procedural defence, so haven't you just shot yourself in the foot?
No, I'm saying that I think you never get there, but if you do get there, as it's been posited to me, then it would come into play, because it's all part of looking at the case. And that's the answer to my lord's question.
Then you hit Section 47, which basically says that that part of the tort, which is all about, which may include limitation, may not be relevant at all because of aggregate damages. Just changes the nature radically of the tort.
But
so that it may become an irrelevant issue even in the framework of the tort.
But that's only if you get to an inquiry looking at the form of the action and the issues in the litigation. And I don't accept that that's part of the inquiry. But also, I don't, if it's, I repeat the point that if it's so clear cut, if loss is so clear cut, it's not the most significant element of the tort for these purposes anyway. I don't think I can add any more.
Right. Anyway. Where are we going now then?
We're going to Mr. Merricks' appeal against the Tribunal's finding rejecting our case that the application of the rules in the Limitation Act are displaced by the Competition Act and the CAT rules, and it raises a point of statutory construction. Before I start, can I just in answer to the court's question, I think the parties are now agreed that the relevant proportion of remote sales is under 2%. So that's just the question that you raised yesterday. Now, before I develop my submissions, I'll try and take it as quickly as possible because we've lost some time, but can I just cut to the chase and identify what we say is the key error in the Tribunal's judgment? So the 1998 Act provides for the general 6-year limitation period in the Limitation Act to be disregarded, and instead for the Tribunal rules to govern the limitation periods applicable to claims brought in the Tribunal. So there's a bespoke limitation regime, and I'm going to come on to show you the detail of those provisions, which very helpfully the Tribunal's appended again to its judgments. We've got them all in one place.
Yeah.
But the applicable rule for our purposes is Rule 119, subparagraph 2. And if we pick up the Tribunal's judgment, and the rules are at the end of the judgment, so it's core bundle tab 6,
Yeah.
page 204. So the key rule for present purposes is Rule 119, subparagraph 2. And this says that Rule 31(1) to 3 of the 2003 rules, time limit for making a claim, continues to apply in respect of a claim which falls within paragraph 3. And the provision basically applies to cases such as the present, and that's not in dispute. So Rule 119 is the applicable provision. And then if we look at Rule 31, just above that, so we've seen that Rule 31, 1 to 3 continues to apply, but if we look at Rule 31, you see that the relevant time limit, so 31.1, a claim for damages must be made within a period of 2 years, beginning with the relevant date, as defined. And the relevant date, you see that at paragraph 2, is the later of the following. So the end of the period specified in section 47A(7) or 8 of the 1998 Act in relation to the decision on the basis of which the claim is made. Translating that, that's the provision that says where it's a follow-on claim, it's the date of the decision or the date of any appeal following from the decision. I'm slightly oversimplifying it, but that's the gist of of 2A. And 2B is the date on which the cause of action accrued. So you have these provisions continuing to apply. So it's a 2-year limitation period from either of those dates. And in the present case, it's 2A that's relevant. So this claim was brought within 2 years of the judgment of the Court of Justice, which was the ultimate appeal judgment following the Commission decision, from which this claim follows on. And so what we see, and then we see 4, so subparagraph 4, no claim for damages may be made if, were the claim to be made in proceedings brought before a court, the claimant would be prevented from bringing the proceedings by reason of a limitation period having expired before the commencement of section 47A. And so the key point in this appeal is that Rule 119.2 preserves paragraphs 1 to 3, but doesn't preserve subparagraph 4. And it's subparagraph 4 which preserves limitation defences which have accrued under the Limitation Act. And we say that therefore Rule 31.4 doesn't apply to these proceedings because it hasn't been preserved, it's been omitted. Now, had the legislature wanted to preserve paragraph 4, then it would have been very easy in Rule 119.2 to say Rule 31 continues to apply, but it hasn't said that. It's deliberately omitted subparagraph 4. And we say that that omission has to be given effect. And the only effect it can have is to ensure that all claims to which 119 applies, which are within the limitation period set down in Rule 31, 1 to 3, can be brought in the tribunal, regardless of whether they were time barred under the Limitation Act. That's what we say the effect of it is. Now, the tribunal rejected this submission, so the tribunal held that the decision to omit Rule 31.4 doesn't matter because it said that accrued limitation rights weren't abrogated in the first place. But that leads to 2 problems, we say. So if accrued rights to plead a time bar under the Limitation Act if they weren't abrogated by the tribunal rules, then Rule 31.4 never served any purpose in the first place. So it would have been entirely unnecessary to have had Rule 31.4 if the position was that limitation defences were preserved even under this new limitation regime. So on the tribunal's reasoning, the legislature's decision to enact Rule 31.4 in the first place was pointless, and the legislature's decision to omit it.
Why was it pointless? If you were just setting out in 2003, you would want to just make provision for claims not to be capable of being brought if they were to be brought in civil proceedings. There would be a limitation defence to stop somebody saying, but it's 2 years from either of the dates in subparagraph 2. Why do you say 4 would have no purpose?
So what my law's putting to me is that it's somehow an avoidance of doubt provision.
Well, no, it's to stop somebody saying, well, I know if I was going to pursue a claim separately in a court, I would be met by limitation defence.
Yes.
But I can
participate in a claim covered by Rule 31 because it says that the limitation period is 2 years from the relevant date.
Yes, so my lord, the way our argument works, and I'm going to develop it in more detail, but the way it works is to say that what the Act does, and I'm going to come to the Act shortly, is to say that the general limitation rules no longer apply. And what we have is a bespoke limitation regime set out in the tribunal rules, which is different. So it's a 2-year limitation period following on from the relevant date. So the 6-year limitation period, etc., in the Limitation Act no longer applies. And it's all about the 2-year limitation period. It's a bespoke, they don't coexist side by side. And what 31(4) does, we say it does serve a purpose, and its purpose is to preserve accrued limitation rights. So it's saying, okay, well, the Limitation Act regime has been replaced, but if you've got an accrued right under that regime, it's preserved. And so that's the purpose of 31(4). But then what we focus on is the fact it's then been deliberately omitted in Rule 119 to this category of cases. And so the preservation of rights doesn't apply to cases to which Rule 119 applies. That's in a nutshell our argument.
So the effect of 31(4) would be, in effect, that any claim where the cause of action accrued prior to whatever the date was in 1997 would be time barred.
Yeah, so
and was time barred from 1992 right away through until the 2015 rules came into force.
Yeah, so more broadly, what we say is that it's not disputed that Rule 119 applies to this case because the case.
I'm just trying to work out what the practical effect of what you're submitting is. The practical effect is that a claim, in my example, which was time barred because it accrued, the cause of action accrued more than 6 years before the coming into force of the tribunal of Section 47A, which was the date I think in 2003. I forget which date it was. Doesn't matter. Let's say July. 1st of July 2003. So any claim where the cause of action accrued before the 1st of July 1997 was time barred in July 2003 and remained time barred right the way through until the 2015 rules came into force.
Well, yes, but the way we look at it is to say...
Is that right?
That's right, yes. So,
but on your case, that claim is no longer time barred because of the effect of the 2015 rules.
Yes, exactly. That's our case. That's our case.
It's pretty odd, isn't it?
Well,
is that really what Parliament intended?
Well, my lord, that's so. The.
I mean, putting it bluntly, all of these provisions are absolutely impenetrable, and somebody needs to get hold of them all, shake them up, and start again.
So, my lord, I'm going to take it quite slowly, and you're right to say that the tribunal thought that was odd, and in fact, there are, the Court of Appeal looked at this question obiter, and also thought it was odd, and reached a conclusion that was unhelpful to me. So I'm not shying away from that.
Odd.
Yes, and I'm not shying away from that. So I start on this appeal 15 love or 30 love down. So I accept that. But I'm very much hoping it's not game over from the moment I stand up, and that you'll listen to my arguments, which are different.
I'm sorry, I shouldn't have interrupted you. Let you get on.
No. But I mean, we've cut to the chase, which is the tribunal thought this was very odd, and so strove, as did the Court of Appeal, as I say, obiter, think it's very odd.
DSG, yeah.
And so exactly, and so construed the legislation against our position in a way that's unhelpful to us. But what we say is that that's, in a sense, looking at things the wrong way round with respect, because one starts, the exercise of statutory construction is to say, what did the legislature intend? And the problem with trying to make sense of this and saying, well, that's very odd, let's interpret it this way, is that it's not giving any effect to the deliberate omission of Rule 31(4).
And
so that's
unless
really...
that were just for the avoidance of doubt, and removing it just leaves the basic proposition that prescription remains.
Yes, my lord, can I now take it in turn? Because I didn't want to sort of front load all of my arguments. I wanted to just cut to the chase to try and explain what the point is that arises. Can we look at the statutory framework in a little bit more detail? So if we go back to page 198, so this is section 47A when it was enacted in June 2003. And as your lordships will know, before 2003, a private action for damages for breach of competition law could only be brought in the High Court. But the Enterprise Act introduced this provision from 20th of June 2003, and that enabled follow-on claims to be brought before the tribunal.
Yeah.
And going through the provision, so we have section 47A, which you're very familiar with. Section 2, subsection 2 defines the relevant prohibition. And then subsection 3, for the purpose of identifying claims which may be brought in civil proceedings, any limitation rules that would apply in such proceedings are to be disregarded. So going back to 1, sorry, I should have dwelt on this a little bit within a little bit more detail. The section applies to any claim for damages or any other claim for a sum of money which a person who has suffered loss or damage as a result of the infringement of a relevant prohibition may make in civil proceedings brought in any part of the United Kingdom. So those are the claims that can now be brought before the tribunal. And subsection 3 says, in identifying those, the limitation rules are to be disregarded. And then 4, a claim to which this section applies may be brought in proceedings before the tribunal. So that's the framework. And then we see that Parliament...
Can we just be clear that 3 is not actually doing anything in relation to limitation periods. It's just saying, for the purpose of identifying under subsection 1, a claim that somebody might bring in civil proceedings in the UK, just forget limitation defences for now. It's for the purpose of identifying the type of claim.
Well, my lord, we say that that isn't the right interpretation of it, and that the right interpretation of it is effectively to remove the application of the Limitation Act, and that that's because a new bespoke regime was adopted for the tribunal.
That's because of the 2-year provision that was in the rules.
Yes, so
why does it say for the purpose of identifying claims which may be made in civil proceedings? Isn't that just referring back to the exercise which you're invited to do under subsection 1? You just disregard, not disapply, you just disregard for the purpose of identification. Because otherwise somebody would say, it's not such a claim because it's subject to a limitation defence. Isn't it just, as it were, for the avoidance of doubt?
well, my lord, we say that I have to say is what how the tribunal read it too, but we say that that's wrong with respect. And can I just explain why we say it's wrong? I'm going to come to this in a little bit more detail, but
don't go out of your way. It's difficult enough without me dragging you out.
no, but it's helpful to sort of, you have got to the part of what the key points are, which is helpful. But essentially, and I will come back to it, but we say that on that narrower construction of what section 47A3 is doing, it would be an odd construction, because when you identify claims, you're not really concerned about limitation periods at all, because limitation periods don't go to the jurisdiction of a tribunal or a court. They're defences which may be raised, and if they're not raised, then the claim...
Is it doing no more than saying, because this section isn't retrospective, is it doing no more than saying that if you bring a claim on the 1st of July 2003, in my example, then you will disregard whether that claim would have been time-barred if it had been brought in proceedings, because there is now a new regime for limitation in Rule 31. And then what then happens is, when you go to Rule 31.4 makes clear, so far as claims which are already time-barred were concerned, then you're still out of time.
My lord, that's exactly what
That's
we
the
say
point.
it does. So that's exactly what we say this provision does. And also, I just ought to say, I've taken you to that by way of background, but the actual provision that
I'm not
applies...
sure that answers the point about the oddity of what happens thereafter, but I mean, as at 2003, that seems to me to be how the thing sort of slots together.
Yes, and that's we say that's correct. And let me take it in stages, if I may, because it is quite intricate. So I don't want to avoid any questions, but if I could just take it instead. Do you have a burning question, my lord?
It'll smoulder for a bit.
I don't mind. You can try it now.
No, because I'm not sure that I'm in the same place as the Chancellor at the moment, because at the moment, if you're looking to what this section is doing, the key part of this section surely is actually subsection 4, which is saying for the first time, if you've got a claim of this type, you can bring it before the tribunal. You don't have to, but you can.
Yes.
And everything that precedes subparagraph 4, subsection 4, is actually just defining the claims that you now for the first time can bring in the tribunal. It's not actually doing anything at all about to limitation. It's just saying these are the sorts of claims that are specified in 1 and 2, and just to stop a clever clog saying, but you can't bring it because it's subject to a limitation defence. It's saying forget limitation just for the purpose of identifying the forum in which you now can bring the claim.
Well, my lord, that's what the tribunal
I know
held.
that, sorry,
That's what the tribunal held, but we disagree with that. So we agree with the way that the Chancellor's put the points. But if I can take it in stages.
You could still, at this stage,
Yes.
you could still bring the claim
Yes,
in the Chancery Division.
you
or
could.
indeed in the Commercial Court, because
Yes,
people do.
which you still can do. Of
And you
course.
still can.
Yes.
But so far as that's concerned, surely would the effect of section 47A(3) as it then stood mean that there was no limitation period applicable to claims in court?
No.
That would be pretty odd, wouldn't it?
No, it wouldn't. So the for in the Chancery Division or Commercial Court.
The 6 years still applies.
Yes, exactly.
As at this stage.
Yes, and so going over the page, because the provision, that's the precursor.
It's claims which may be made in civil proceedings, not claims which are made.
No, exactly. Now, my lord, going over the page, so section 47A, as at 1st of October 2015, which is the pertinent provision, I showed you the precursor to it, but this is relevantly similar, it's ordered slightly differently, but you can see the analogous provision to subsection 3 is at subsection 4. So it's the same point, but it's at subsection 4, but this is the one that applies. I want to take you to DSG, so what the Court of Appeal found in DSG, because part of it's unhelpful to me, as I've canvassed, and I'll come back to that in due course, but part of it is helpful. So if we can turn that up, please, at tab 35 of the authorities.
So just so I know, and I think somebody has said, this section applies to Scotland as well as the UK, as well as England Wales.
That's right.
So, although we talk about there being a limitation defence, this also has to cater for prescription. Yeah, prescription.
It does, and
in fact there isn't a claim at all.
It does, and I'm going to address that point separately, but you're right.
Yeah.
So if we could pick up Authorities Bundle 2, tab 35, and of course the Chancellor will no doubt remember this case. And if we go please to 1225. And paragraph 54. So starting then at the beginning, the words of Rule 31, 1 and 2 provide for present purposes that a claim for damages must be made within 2 years of the final determination of the competition authority. That is, as the claimants submit, a new limitation period in respect of a new way of bringing follow-on claims through the tribunal. Prima facie, I agree also that Section 39 of the Limitation Act operates so as to exclude the application of that Act where Rules 31, 1 and 2 apply. And so we say that that's consistent with what I've said is the proper construction of 47A4, which I think is the point that the Chancellor was putting to me, which is 47A4 strips out the Limitation Act because there's a new bespoke limitation regime which replaces the old Act. But then what you have is 31(4) preserving accrued limitation defences. Now, then we get to Rule 31(4), and if we look at, again, we're still on paragraph 54. So we see that it's directed at what should happen to claims for damages if, were they to be made in court, they would have been time barred before the Enterprise Act 2002 came into force. So the Enterprise Act is the act which provided the vires for Rule 31. And then at 55, I don't see that the meaning of Rule 31(4) is ambiguous. It may be that the legislature could have used the word claim. We don't need to get into that. It's a point which isn't exactly relevant. But then 55, the saving, further down in 55, the saving in Rule 31(4) would therefore have been looking back to the previous limitation regime and preserving accrued rights to plead a time bar. So we say that that's all correct. So we agree that that's the effect of Rule 31(4). It provides that a limitation defence which had accrued before Section 47A came into force would not be abrogated by reason of Rule 31(4). Now I'm going to come back to the unhelpful bit in DSG, but I want first to complete the statutory framework. So can we go back to the tribunal judgment in the core bundle behind tab 6 and go to page 200? So we just looked at this provision, but just following on from what I said, you'll recall that this amendment came into force as of the 1st of October 2015, and it gave the tribunal full jurisdiction for competition damages claims, whether follow-on or standalone, which is parallel to the jurisdiction of the courts. And of course, it also introduced the new collective actions regime. And we've looked at 47A4 already. At the same time as Section 47A was amended, a new Section 47E was introduced. That's over the page. Now, what that does, in fact, that provision has now also been repealed, but that's not relevant for these purposes. So Section 47E provided for the Limitation Act to apply in proceedings before the tribunal. However, under the transitional provisions in the 2015 Act, Section 47E doesn't apply to proceedings which arose on or after its commencement on the 1st of October 2015. So that's why this case is not under that provision. So it's agreed, it's common ground, that this provision is of no application to these collective proceedings. So what limitation period applies to the current proceedings? That's determined by the tribunal rules, which came into force on the same date, October 2015.
So hang on a minute, just, I found this very difficult to follow. I've looked at it before. As at 1st of October 2015, is this right? The 6-year limitation period under the Limitation Act was revived.
Yes.
Despite Rule 31 of the previous rules.
That's correct, but it doesn't, under the transitional provisions in the Act, it doesn't, that section 47E doesn't apply to proceedings which arose on or after its, arose before its commencement, but were issued after its commencement. So that's this case. So,
Yes.
and that's common ground.
Yes.
And so then you ask yourself, well, what limitation rules do apply to this case and cases that fall in that transitional slot? And that's determined by the 2015 rules. And we've looked at, if you go over the page, that's Rule 119, that's what applies to this case. And you see that Rule 118 revokes the 2003 rules. So they revokes them completely.
Yeah.
And then we see the transitional provisions, which are at Rule 119, which is entitled Savings, which you'd see that, I think we don't have the heading here, but it is entitled Savings. And then 119, just to take it slightly out of order, if you look at 119 subparagraph 3, a claim falls within this paragraph if it's a claim to which section 47A applies and the claim arose before the 1st of October 2015. So it applies here, and then 119.2 is the critical provision, which you've seen already. So the position is that for claims arising before the 1st of October 2015 but brought after that date, we say this is the position. Section 47A4 disapplies the Limitation Act. Rule 31(1) to 3 apply, and that provides a 2-year limitation period as from the date of the relevant decision. And Rule 31(4) does not apply, so there can be no saving for accrued rights. So that's how we say the statutory scheme works.
What you then get to is this right? Is that insofar as the any part of this claim arose before 1997, it's brought, or any limitation defence that was available in respect of it has been removed by Rule 119.3 or Rule 119.
Yes, because, yes, and the reason for that is because the limitation defences were removed by 47A4 and by, as the Court of Appeal found, the substitution of a bespoke limitation regime. So the two things can't exist side by side.
But the bespoke regime didn't apply
So
to what the position was before 1997, did it?
Well, the bespoke regime in Rule 31(4) preserved limitation defences, but that preservation is taken away for cases in this category by Rule 119, and particularly the omission of the preservation of Rule 31(4).
Yeah.
So that's the argument.
So we've got a tricky issue of construction, so we would always look to the purpose. What's Parliament's purpose? What would Parliament's purpose be in opening up limitation? Limitation is par excellence about legal certainty. So a bank, MasterCard, can identify contingencies for potential litigation and so on. What would be Parliament's purpose in opening up that new head of liability without using, I think we all accept this ambiguity, without using the clearest possible words and making its intention very clear? What is that purpose?
Well, my lord, can I give you 3 answers to that? So the first answer is we say that it did make its intention clear by the deliberate omission. So we say that has to be given effect. And the second answer is that that nothing in the tribunal's judgment or MasterCard's argument actually gives that omission any effect. And so the starting point for statutory construction is, what do the words say? And so it's
on an omission, not a commission.
It's an omission, but we also have the positive point about section 47A4, which is a positive deletion of the limitation right, subject to the point that Lord Justice Snowden put to me, which I'll come to. But if we're right about that, it's not just an omission, it's how the scheme falls to be read. But we say an omission, in any event, is to be given effect because it's deliberate. Nobody's suggesting it was an error, so it's a deliberate omission.
Normally what's meant by clear words, and that when, for example, well, there's plenty of cases where you look on principles of statutory interpretation and you only take an extreme position if they're clearest possible intention. So it generally requires not only positive words, but clear and unequivocal words which address the harm that it's going to create for an adversely affected category.
Well, my lord, I'll come to the test, because we say it's not quite as high as that, but I'll come to that very, very shortly. But it may be that this is, so the bespoke regime had been in place, obviously, for some period of time. And it may well be and the regime was going to change yet again. It may well be that Parliament considered that that the simpler system was just to have these cases subject to the new regime, and that actually on the facts, given the amount of time, given that these are follow-on claims, on the facts there's unlikely to be much of a problem, because the idea that there'll be many cases in which there are accrued limitation rights which would be abrogated by the omission of Rule 31.4 becomes less and less likely as time goes on. So that may have been the reason.
There's no admissible extrinsic material that we have recourse to.
No, and there isn't, and no side has been able to produce any, but you've asked me the question and that's the best I can do.
But then, of course, you do have the concealed fraud provisions which enable people to bootstrap, because the decision comes out, it's the first time the cause of action has become manifest and transparent. That protects that. I'm struggling to find a macro policy that would have been in Parliament's mind justifying opening up something which all the companies concerned had considered was a legally certain position.
Well, my lord, I think we say we look at it the other way. So the starting point, we say, is that the Limitation Act is that's out the window. So that's Parliament's got rid of that. And then there's a limited saving in 31.4, which is then removed. So it's not a question of, so the starting point is that no one can assume that their limitation defences are protected, because the regime has changed. It's just an entirely different regime at this stage. That Parliament, the legislature's made a saving provision in 31.4 and then taken it away. Now, I think...
I mean, it may be that it's no more than that. For whatever reason, whoever was drafting these new rules thought, well, 31.4 isn't necessary anymore because it's all so far away in the past.
Exactly.
It's never going to arise, and they just haven't thought about the possibility they might do.
My lord, exactly. That's the best I can do. But really, there's almost a sort of question of principles to the approach here. So, what the tribunal found and what the Court of Appeal then found, and I'll show you the next part of DSG, which is unhelpful to me, is, well, this doesn't terribly make much sense. Let's try and fix it by, I'm just summarising, I'm not intending to be pejorative in any way, but let's fix it by a process of interpretation. And we say that is the wrong approach. So statutory construction starts with the words, and here there's a deliberate omission. And we say that deliberate omission has to be given effect, and no one has given it effect other than on our argument.
Is the effect of your argument in relation to Scottish matters to create a new cause of action?
My lord, that's a little... Can I just come back to that? Not because I'm trying to avoid the question, it's just that it's a particular issue that I can't answer in 2 sentences. It's going to take me about 5 minutes to show you. And I would just, if you don't mind, just rather finish my submissions on the main point.
You're going to show us DSG again.
I'm going to show you DSG. Well, can I first of all go to Lord Justice Green's point about the test? And if we look at the... let's go to the tribunal's reasoning. We can take it from there. So, page 142, CB 6, page 142.
Yeah.
So what we see at 31 to 32 is the Interpretation Act, and we see, without prejudice to section 15, where an act repeals an enactment, the repeal does not, unless the contrary intention appears. So I just underline those words mentally. And then affect any right, privilege, obligation or liability acquired, accrued or incurred under that enactment. So far as the Limitation Act is concerned, the question is, does the contrary intention appear? And we say, well, it appears because of the deliberate omission. And then we have, the tribunal then looks at U Bon Chu, so this is paragraphs 32 to 32 onwards. So 32 the relevant part is set out there. An accrued right to plead a time bar, which is acquired after the lapse of the statutory period, is in every sense a right, even though it arises under an act which is procedural. It's a right which is not to be taken away by conferring on the statute a retrospective operation unless such a reconstruction is unavoidable. So the test is there a contrary intention? Is the construction unavoidable? And then just going through the tribunal's reasoning, so paragraph 34, the tribunal notes the oddity that was put to me by my lord. So if these claims had been brought before the 1st of October 2015, they would have been subject to the 2003 rules, in which MasterCard would have been entitled to rely on 31(4), and so this point wouldn't have arisen.
No.
And the tribunal observes that because these proceedings were brought after the 1st of October 2015, they're subject to the 2015 rules, and so 31(4) doesn't apply. And then the tribunal says, and that's halfway down the paragraph, but Rule 119 does not express a contrary intention for the purposes of the Interpretation Act, either to affect any pre-existing right of a defendant to plead a time bar by reason of the expiry of the limitation period, or to revive an obligation which had previously been extinguished by prescription. While the omission of incorporation of Rule 31(4) may appear surprising, we consider this omission cannot lead to an unavoidable construction of Rule 119 as affecting previously acquired rights of limitation, and it has no bearing in any event on the prescription period. I'll come back to Scottish law. So the tribunal's reasoning is that the omission can't lead to an unavoidable construction of Rule 119, but we say, with respect, that that's wrong, because Rule 119 does express a contrary intention, because it would have been as easy as anything simply to preserve Rule 31, but it hasn't. It's specifically, the legislature specifically preserved Rule 31, 1 to 3. And I'll come back to this, but we also say that the other point I've made is there's a further important contrary intention expressed by the legislature, and that's the express provision in section 47A4. So we put our case in both ways. Now, the tribunal rejected that argument.
47A4 was in the previous 47A as 47A3.
Precisely. And it's really...
It was shut out, as it were, by 31(4).
Exactly. So
you say, well, once 31(4's gone, then 47A4, as it now is, springs into life.
Exactly. So the order is 47A4 gets rid of the Limitation Act. The Court of Appeal in DSG, the bits that I've shown you already, say, well, the two things, there's a bespoke limitation regime under Rule 31 that replaces the Limitation Act.
Yeah.
Then you have Rule 31(4), which preserves accrued rights under the Limitation Act, and then 119, which omits that preservation. Now, the tribunal, this comes back to the point put to me by Lord Justice Snowden, because the tribunal took the same point as Lord Justice Snowden. I don't think you can call it a point if you're the judge, but the same point.
I was just putting the point to you. Actually.
Yes, you put the point to me. Not your point, you put it to me. And the tribunal did reach the same conclusion on the basis of the tribunal's judgment in Deutsche Bahn and Pilkington. So it's very confusing, all the Deutsche Bahns and DSGs in these proceedings, but it's a different Deutsche Bahn case. And I'll come back to that. And then if we go, you see that from paragraphs 36 through to 39. In fact, if you just read to yourselves paragraph 38, you see the point that was put to me by Lord Justice Snowden. That's where the tribunal reaches that conclusion. And I will come back to that point. And then at paragraphs 40 to 42, the tribunal placed weight on the court's judgment, this court's judgment in DSG, although it accepted that in the relevant respect the judgment was obiter. So we've separated our grounds into 4 grounds of appeal, but I think it's more efficient just to take them together. And we say that the key error in the judgment is the tribunal's conclusion that the legislation doesn't contain a contrary intention for the purposes of section 16 of the Interpretation Act, and that Mr. Merrick's construction of the legislation is not unavoidable, which is the test in New Bon Chu. And as I say, we've advanced two submissions. The first is that these requirements are satisfied by Rule 119 itself. That's the deliberate omission point. And the second is that the contrary intention or unavoidable construction is also to be found in section 47A4.
Can I just ask you this about the rules themselves? When the statute conferred upon the tribunal the right to lay down rules, it didn't tell you which way the limitation rules were going to go, it just created a power.
It did.
So the taking away of the right of limitations come through secondary legislation.
Well, yes, but through the Enterprise Act, which
Confers the power.
Yes, it confers a power.
But the choice of how the limitation operates is done through secondary legislation.
That's correct.
That's quite a strong thing to do by secondary legislation, to take away pretty important rights. It's normally done, those sorts of things are generally done through primary legislation. I'm not saying you're wrong, but it's constitutionally, this is 5.5 years in the Law Commission thinking about this sort of thing. Do you do it primary or secondary? Generally, secondaries for procedural matters, that's not an absolute rule.
Yes, but my lord, this all happened at the same time. So I think that I don't have at my fingertips the pre-legislative material, but the scheme was conceived as a scheme with a new limitation regime. So it happened at the same time. So I understand the point that you're putting to me.
Logically, the Act has to come into force before the rules can be adopted.
Yes.
Whether it's by negative or affirmative resolution, but the power has to, it has to be sequential. It can't be at the same time.
Yes, that's correct. But whichever way you look at it, my lord, so whether you look at it as section 47A4 removing the application of the Limitation Act, which is what we say, or whether you look at it in the way that the Court of Appeal did in the section of DSG I showed you, which is once Rule 31 comes into play, the Limitation Act necessarily disappears by operation of the Interpretation Act, because it's been replaced by a bespoke regime. One ends up at the same point, which is the Limitation Act goes, and 31.4 was necessary in order to preserve existing defences under the Limitation Act. So it wasn't an avoidance of doubt provision, it was a necessary provision. And you can get there either through 47A4, if you're not with me on that, through the adoption, as the Court of Appeal said in DSG, of Rule 31, that operates to exclude the Limitation Act. So either way, you end up in the same result. You need 31.4, and then the preservation is then deliberately omitted. Now, and as I say, the difficulty with the tribunal's judgment is that it says, oh, well, it's very surprising that the legislature didn't just preserve the whole of Rule 31, but it doesn't give any effect to that decision. So it comes back to the point of principle, which is, what's the proper approach to this? So everyone says, well, it's a bit odd that this has happened, but it has happened. Nobody suggests that it's a mistake, so it's accepted that it's deliberate. And so we say the proper approach, the starting point, yes, you can get into purposive constructions if things are unclear, but the starting point is to look at the words, and the omission must be given effect. That's really our key submission. Now, I just want to go back to DSG. So it's tab 34 of the authorities. And if we take it from, I'm so sorry, tab 34 is the tribunal judgment below, and I would like to start with that. So this is the judgment that led to the appeal in DSG that I am going to come to. And if we take it from page 1159, and you'll see that there were cases brought by DSG, Dixon's, and Europe Car. So there were a number of proceedings that were considered at the same time. And if we go to page 1159 and look at paragraph 37, so the tribunal in that judgment says the preservation of Rule 31.1 to 3, but not Rule 31.4, is clearly deliberate. Mr. Hoskins very properly accepted this is not a case of a drafting error, nor does he suggest that a limitation right can be regarded as a human right. In our judgment, the conclusion is unavoidable that the time bar imposed by Rule 31.4 in circumstances where the limitation period would have expired prior to 20th of June 2003 does not apply in the case of proceedings commenced on or after 1st of October 2015, which are governed by Rule 1192. So that's precisely what we say is correct. Now, Mr. Hoskins' submissions were in effect an invitation to incorporate by a process of construction the substance of Rule 31.4 as regards proceedings which are governed by Rule 1192, but that would be directly contrary to the language of Rule 1192, which expressly chose not to incorporate or save Rule 31.4. Accordingly, Section 16.1 of the Interpretation Act does not assist, and the case does not fall within the U bon tu principle. Follows that whereas Rule 31.4 applies to proceedings commenced before the 1st of October 2015, it has no application to proceedings commenced thereafter. So pausing there, we say that that's completely right. That's the right construction and the right application of the Interpretation Act and U bon tu. Then the tribunal found at paragraph 38 that that would produce an odd result, and we've discussed the odd result already, namely that proceedings commenced before October 2015 would be time barred, but those commenced after that date would not be. And that drove the tribunal, so that odd result drove the tribunal to construe Rule 31.4 narrowly so as to preserve the limitation defence only in respect of proceedings where the entirety of the claim would have been time barred under the Limitation Act. And you can see this if you go to paragraph 40 on page 1161. So you can see it in the middle of paragraph 40. So the follow-on proceedings brought after the decision finding infringement will normally seek damages for the losses resulting from that infringement. Those proceedings will therefore comprise a series of claims for each cause of action constituted by each day that the infringement continued. And the preclusion of claims applies if proceedings bringing the claim would have been time barred before the court and not simply if the claim would have been time barred. So that's their interpretation of Rule 31.4 to try and avoid the consequence that it says is undesirable. But pausing there, the desire, as I've said, the desire to avoid the consequence of this distinction between claims brought before and claims brought after 2015 has been the factor that has driven all three judgments on Rule 31. So this one, the Court of Appeals in DSG, which I will come to, and the judgment below. And our essential point is that the desire to avoid that consequence should not drive the proper construction of the words of the statutory provisions, because whenever an accrued limitation right is abrogated, there will always be a cut-off point at which a time-barred claim is revived. And the tribunal's starting point is that that's an inherently illogical outcome, and therefore it was unwilling to construe, the tribunal in our case, in the present case, was unwilling to construe Rule 119 in such a manner. But of course, limitation rights can be and are abrogated. That's what U bon tu is addressing. So the correct test for determining that issue is the one set out in U bon tu, which we've looked at. So the court must ask, is such a construction unavoidable? The test is not to avoid such a construction at all costs. The test is it unavoidable? And it's not correct to start from the assumption that it would be inherently unlikely for the legislature to abrogate accrued limitation rights. The test is the construction unavoidable? Does the contrary intention appear? And we say, you have my submissions on that, so we say it does appear. And now if we go to the Court of Appeal in DSG, so behind tab 35, and if we start with 1226, the Court of Appeal rejected the Tribunal's narrow construction of Rule 31(4), and it also briefly addressed the question at issue here, namely the relevance of the omission of Rule 31(4) in Rule 119. But if we look at paragraph 59, we see, and look at the final sentence of paragraph 59, it should be emphasised that we are not asked to decide this question on this appeal because the Europe Car proceedings which raised the point were compromised shortly before the appeal hearing began. So it is, the tribunal below was right to say that the consideration of this point by the Court of Appeal was obiter. And then if we look at paragraph 60, the legislature's decision in 2015 to apply Rule 31(4) to proceedings begun before the 1st of October 2015, but not to those begun afterwards, may have been deliberate, as the tribunal suggested, but that does not inform the question of whether, in the absence of Rule 31(4), accrued limitation rights are to be abrogated. I accept it would be illogical and unsatisfactory to determine that those rights survived in proceedings started before October 2015, but did not in proceedings started after October 2015. And then the court says, the extant legislation must be construed in accordance with section 16(1). Rule 31(4) may be disapplied, but that disapplication cannot, unless the contrary intention appears, affect any right acquired under that enactment. A contrary intention does not appear in the 2015 rules. So that really crystallises the debate. So does the contrary intention appear in the in the rules? And we say it does because of the obvious omission. That's the contrary intention. That's the point that the Court of Appeal took a different view on. But we say with respect that that's wrong. And we also do rely on section 47A(4). And if I could just turn to the to deal with the point that the so going back, if we go back and stay in the same judgment for a moment and just remind you of what was said at the beginning of paragraph 54 on page 1225. So that the argument based on 47A(4) doesn't appear to have been advanced before the court, maybe because the point was not an issue by the time of the appeal hearing. But what you see in paragraph 54 is completely consistent with the view that the limitation rules in the Limitation Act are now no longer there because they've been replaced by a bespoke regime. And going back to the tribunal's point about 47A(4), which is the point put to me by Lord Justice Snowden, you saw in the judgment that it based its conclusion on the decision in Pilkington. Let's turn up that judgment, please. That's behind...
Just before you do,
yes.
Can you remind me what section 39 of the Limitation Act says?
Yeah, so section... I'm not sure if we have that in the bundle, but it's... Let me find it. Can you find it so I can read it out?
What's the provision? Is it something about specific...
It is, but let me just find it exactly so I can read it out.
Specific, I think it's a specific in general.
So this act shall not apply to any action or arbitration for which a period of limitation is prescribed by or under any other enactment, or to any action or arbitration to which the Court of the Crown is a party. So it's yielding to the specific.
Yeah.
So just looking at the start of paragraph 54, which you asked us to look at.
Yes.
I think this says nothing about section 47A.
No,
does it?
it doesn't.
In fact, frankly, it's perfectly understandable as simply saying that there is a special period of limitation in Rules 31, and that's what applies in relation to proceedings in the tribunal.
My lord, I agree.
So you don't need section 47A to do the job that you say it did.
No, I agree. So that's that exactly. So that's why that's a further basis on why 31(4) was necessary, because once the once the new bespoke limitation regime under Rule 31 was put in place, then by virtue of the Interpretation Act, as the Court of Appeal said, the more general regime was displaced. So you're right that I don't need Section 47A4. It's another string to my bow, but I don't need it. But it's consistent with, so our construction of 47A4 is consistent with how this operates, with the effect of Section 39. So it's consistent with it because it's...
I'm not sure why it is consistent. I mean, the point is you don't need it. If you don't need it to do anything,
Yes.
because you've got the wherewithal to bring into place the new limitation regime,
Yes.
by using the combination of Rule 31 and Section 39 of the Limitation Act 1980, then actually it's not consistent with your interpretation of 47A4 because you're trying to make 47A4 into a sort of bell 2040 got braces, if I can use that expression.
Well, my lord, perhaps the better way then of putting the point is to say, so the reason that the underlying point is that Rule 31(4) was required in order to preserve existing limitation defences. So, and that's because, so if we look at paragraph 54 and leave aside section 47A4 for the moment, that's because there's a new bespoke regime which displaces the Limitation Act. And so it's displaced. So that then the question is, what happens to accrued rights? And Rule 31(4) says they're preserved. And then you have Rule 119, which does not omit that displacement. And the question is, what's the effect of that?
Well, that's a more if I may say, that's a more streamlined argument, which doesn't dip into the reeds of section 47A4.
My lord, yes, I can see that. I can see that, and I think it's yes. I mean, I accept that. I accept that that's a more streamlined argument, and it's to exactly the same effect. So the question is, what does the statute say? What does the legislation say? What's the meaning of the legislation? And the meaning of the legislation is the Limitation Act is displaced. You have to have a positive preservation of accrued rights. We got that in Rule 31(4), and then that's deliberately omitted. So the deliberate omission has to mean something.
But, I mean, 47A4 or 47A3 as it was
Yes.
when it came into force. So if, as at the 20th of June 2003, you had a claim that you bring a claim in the tribunal. What it's saying is it's not so you bring a claim in the tribunal, say in October of 2003. What it's saying, as I read it, is it's not open to the defendant to say, well, actually your claim is time barred in respect of anything that occurred before October 1997.
Yes.
But in other words, looking at the limitation position once this provision has come into force.
Yes.
But what 31, and the reason for that is because you've got this new regime in 31.
Yes.
But so far as any claim that was time barred as at the date when this came into force is concerned, 31(4) says, well, you're still out. The claim's still time barred.
The omission of 31.
But on one view, you could construe section 47A3 and then 47A4 on the basis they don't have retrospective effect. You could construe them as arriving at the same result, even if you didn't have 31(4).
Yes, and that was the way that I put the argument. And what's put to me by Lord Justice Snowden is I don't need that argument because I've got a more direct route. But I say either route will do, but they're both going in the same direction. Now, the reason
the point I'm making, I think, is a point against you rather than in your favour.
Yes.
I'm making the point that irrespective of 31(4), claims that were already time barred as at the date when these provisions first came into force remain time barred. Because 47A3 or 4 is only looking at as it were, the position after these provisions come into force, because they're not retrospective.
Well, I think the position is...
You wouldn't expect, if you forget Rule 31 for the moment,
Yes.
you simply wouldn't expect an accrued limitation right to be removed by, well, I would have said that 47A3 as it was insufficient to amount to a contrary intention for the purposes of Section 16 of the Interpretation Act.
My Lord,
It's not touching what is already time barred.
No, I mean, the way that the tribunal, so the meaning given by the tribunal to 47A3 and then 4 is that it's defining the proceedings that can in
Well, I
principle...
follow that. I follow that you said that may be the wrong way of looking at it.
Yes. But we say that's the wrong way of looking at it because and the key point on that is that it would be odd because limitation doesn't affect the jurisdiction of the tribunal. So when you're considering what are the claims over which may in principle be brought, you're not looking at limitation defences because they don't affect the jurisdiction of anyone, of any court or tribunal to hear a claim. They only matter if they are raised by way of defence, and sometimes they're not raised and the court still has jurisdiction to hear them. So it's an odd provision if that's what it means. But we say anyway, leaving that aside and taking the more streamlined route, we say that once you have Rule 31, 1 and 2, which is a bespoke regime, the Limitation Act is displaced, and there's then a question which needs to be addressed by the legislature as, well, what do you do if you've got accrued rights under it? And that's what 31.4 preserves. And it's the decision not to preserve that which we rely on. So that's really the argument. And the only point I've got left to address is Scots law. So can I turn to that now? And then I think you've got my submissions on this point. So Scots law, MasterCard and the tribunal say that our argument doesn't work because it would involve drawing a distinction between the English limitation rules and the Scots law of prescription. And let's just see where the tribunal probably makes this point most clearly in its judgment refusing permission to appeal. So if we pick that up in the core bundle behind tab 12, page 256. So paragraph 8, and it's at the bottom of the page. If the class representative's argument under this ground were correct, claims before the tribunal governed by Scots law would be subject to the statutory regime of prescription under Scots law, whereas claims governed by English law would not be subject to the statutory regime of limitation under English law. And we find it inconceivable that the drafters of the rules intended that consequence. So that's the point against me. But we say that it's a bad point because, let's go back to, please, the legislation behind tab 6. And if we start with 47A4, so this argument does depend on my construction of Rule 747A4. So for the purpose of identifying claims which may be made in civil proceedings, any limitation rules or rules relating to prescription that would apply in such proceedings are to be disregarded. So, and you've got my submissions on the effect of that provision. So we've got to assume I'm right on that for these purposes. So just as it does with limitation, it also excludes Scottish rules on prescription. And then if we go to Rule 31.4 on page 204, Rule 31.4 only refers to a limitation period having expired, so it makes no reference to prescription. And we say there are two ways to interpret the effect of Rule 31.4 as to Scots law on prescription. So first, because Rule 31.4 doesn't mention prescription, it means that even if the prescriptive period was extinguished prior to June 2003, a claim could nonetheless be brought in the tribunal if it was within time under Rule 31.1 to 2. Now that would appear to be the most natural reading, but it would prima facie be a surprising conclusion because it would suggest that accrued rights under English law were preserved by Rule 31.4, but accrued rights under Scots law were not. But second, one can read the words limitation period as
It goes even further than that. It's not an accrued right under Scottish law. It's just that the claimant doesn't have one. It's not an accrued right to the defendant to raise a limitation defence. It's just there is no cause of action. It has gone, ceased to be, and all the other parrot jokes.
well, my lord, I was going to say, but I think I'm anticipating you're not going to like this point, that the one can read the words limitation period as extending to prescriptive periods under Scots law, and that wouldn't be a natural meaning of the words, but it may better reflect the legislative intent. But we say that the question of we don't take a position as to which of the alternate constructions is preferable, because if you consider the effect of Rule 1192 only incorporating Rule 31.1 to 3 from a Scots law perspective on either of those interpretations. So if Rule 31.4 did not operate so as to preserve accrued rights under Scots law, and I appreciate that that's not the right phrase, but you get my drift, the omission of Rule 31.4 makes no difference.
One of the oddities is that Section 47A, as originally enacted, simply referred to limitation rules. The reference to rules relating to prescription only came in when it was amended in 2015.
My lord,
that coincided with the omission of Rule 31.4.
Yes, my lord, that is a good point, and I'm not sure what the reason for that is.
I'm not entirely sure what one makes of that.
No.
Other than one possibility is that you're right in saying that as when it was enacted in 2003 to go over the rules,
yes,
it was thought that the reference to limitation would cover both English and Scots law.
Exactly.
And then some bright spark subsequently thought, no, hang on a minute, we need a different provision for Scotland.
I think that's the most likely course of events, and so then what you do is you then.
Otherwise, none of it makes sense, really.
No, exactly. So that's really I think our best short answer to the point on Scots law. My lord, so standing back in conclusion, we say that our position properly reflects the language used by the legislature, and the tribunal's judgment fails to give any effect to the language. In particular, it's not just an omission. It's that it would have been very easy for it's the actual words used, because instead of saying Rule 31 as a Rule 31 is preserved, it specifically says Rule 31.1 to 3. Yeah. So it's not just an omission that's just taken place.
As the tribunal said in DSG, and I think we were inclined to agree in the Court of Appeal.
Yes.
It looks as if it was a deliberate omission, because.
So, my lord,
as you rightly say, if it just intended to get rid of Rule 31, it would have said so. So somebody seems to have turned his or her mind to the fact that they were preserving 1 to 3, but not the whole rule.
Exactly, and so there's a conundrum, and the question is: do you ignore that and say, well, it's odd, so let's try and fix it, or do you, as we say, remain faithful to the statutory language? So those are my submissions on our appeal.
Right.
Thank you.
Well, it's 4:15. We've had a long day.
Yes.
If we were to break now, are we in any danger of not finishing? I mean, you've got to deal with this point.
That's right.
Which is certainly shorter than the last point.
Much shorter, at least here.
And then we've got to deal with exemptability.
That's right. I mean, I hope
I would have thought is also not that enormous a point, is it really?
I would hope that I can make my submissions in 45 minutes to maximum an hour tomorrow. And
how long do you think we need on exemptability?
On this point?
On this point, yes.
And how long do you think we need on exemptability?
It's Cook's
Mr. Cook dealing with that.
I'm afraid it's not perhaps as short as it might appear in the sense that there are two substantive parts to it.
Yeah, sure.
So,
I
yes.
wasn't saying you need
No,
to
so
do it in half an hour or anything like that.
Certainly an hour and a half at least.
What time is the cut-off point tomorrow? So that
Well, I really would like to be away by 3:30 really. So it sounds as if we better sit at 9:30 then.
I think that would be sensible if the court is willing.
You're right, Captain.
I think so.
Well, what I will say though, if we're going to sit at 9:30, we ought to have a break halfway through the morning, because I was conscious we didn't this morning and it was a very long morning. So if we say 9:30, then we'll aim to have a break at about 11:15 for 10 minutes or something. So
Thank you very much.
tomorrow at 9:30.
Call rise, if able.